Hello everyone, welcome to the channel Contract Simplified. I am Advocate Kritika here with a new video all about wills. Let us start with understanding what is a will. A will is a testamentary document by which a person bequests his property to be effective on his death. The property will devolve on the person in whose favor it is bequeathed after the death of the testator. What are the essentials of a valid will? Any person above the age of 18 years and mentally sound may execute will, but a will caused by fraud, caution, and other force, external force will not be valid. Therefore, a will must be executed voluntarily. Parents or guardians cannot execute will on behalf of minors or lunatics. Attestation by minimum two witnesses is mandatory. Scribe, that is, deed writer or advocate, cannot be witness. Two independent attesting witnesses other than the scribe is necessary. Beneficiary under a will shall not sign as the attesting witness. In order to avoid disputes in implementation of a will, description of the property and the beneficiaries should be clearly written without giving room for any doubt. The next one is registration of will. It is not compulsory to register the will. However, executes may register it at their option. However, it is always suggested to register the will. If original will is lost, then a certified can be obtained from the sub-registrar office. It can be registered in any office of the sub-registrar in India. And also, there is no time limit for registration of will. Will can be registered even after the death of the testator. Claiming party under the will have to produce the will, records relating to the death of the testator, witness, and the scribe before the sub-registrar. If sub-registrar is satisfied about the truth and genuineness of the execution of the will, he will be registering the will. Next one is cancellation, revocation, challenging, or rectification of the validity of the will. The testator can cancel his will at any time during his lifetime. Such cancellation deed requires a stamp duty of Rs 100. If executant of a will wishes to rectify or add or modify the will, he may do so during his lifetime. This is called as Codicil. This document does not require any stamp duty. Also, this has to be noted that the validity of will can be challenged in court. Stamp duty and registration fees to register a will. In Karnataka, there is no stamp duty on the will deed. For registration of will during the lifetime of the testator, Rs 200 registration fees is prescribed. To register the will after the death of the testator, registration fees of 200 and an enquiry fees of Rs 250 is prescribed. Please note that this may vary based on the jurisdiction. Certified copy of a registered will. Certified copy of the registered will is available to the testator only during his lifetime. After his death, anybody can obtain after producing proof of the death of the testator. Confidentiality of will. Will can be deposited in a sealed cover in the office of the district registrar. A fees of Rs 1000 is prescribed to deposit will in a sealed cover. Depositor or authorized person, that is executor, can withdraw the sealed cover containing a will if he desires to do so. A registration of Rs 200 is prescribed. Please note that this may vary based on the jurisdiction. On making an application along with a proof of the death of the depositor, district registrar will open the sealed cover in the presence of the applicant and it will be registered. Certified copy will be issued if desired. A fee of Rs 100 prescribed to open a sealed cover. However, again, this will depending on the jurisdiction. Next one will be moving into contents of will. The contents of a will is also known as the last will or testament, typically includes various important provisions and information. While the specific details may vary based on jurisdiction and individual preferences, a standard will generally include the following elements. The first one is title and identification. The document is usually titled as Last Will and Testament at the top. The individuals creating the will, that is the testator, is identified by name and sometimes other details like address, date of birth are provided. However, it is suggested to provide the details in every template. Next one is revocation clause. A statement revoking any previous wills or codicil is mandatory, followed by declaration of sound mind. The testator may affirm that he is of sound mind and under no undue influence or pressure is making the will. Family background. Some testators include information about their family members, beneficiaries, and other relationships. This can help to establish the context for distribution of assets. Followed by declaration of intentions. The testator may declare their intentions regarding the distribution of their property, appointment of executors, guardianship of minor children, and any specific bequests. Appointment of an executor. Naming an executor or a personal representative or an authorized representative who will be solely responsible for carrying out the wishes specified in the will. This person is often a family member, friend, or a legal professional. Followed by guardianship provision. If the testator has minor children, the will may include a provision appointing guardians to take care of them in the event of testator's death. Distribution of assets. Specific instructions on how the testator's assets, including property, money, and possessions, should be distributed among beneficiaries. Beneficiaries are individuals or organizations named to receive the assets. Specific bequests. Details about specific gifts, such as giving a particular item or sum of money to a specific person or organization. Residuary estate. Instructions regarding the remaining assets after specific bequest have been fulfilled. This part addresses how the residual estate should be distributed among the beneficiaries. Followed by contingency plan. Provisions for alternative beneficiaries or instructions on what should happen if the named beneficiary precedes the testators. Next one is debts and taxes. A statement addressing how debts and taxes and other financial obligations should be handled. Funeral and burial instructions. The testator's preference regarding funeral arrangements and burial or cremation. Next one is no contest clause. This states that if any beneficiary under this will contests the validity of the will or any of its provision, then that person shall forfeit any interest in the estate. However, the validity of this clause is a debatable topic. The last one is witness and notarization. The will must be signed by the testator in the presence of witness. Depending on local laws, it may require notarization or registration for added legal validity. So this is all about wills. If you have any question, please let me know via comments. I would like to answer all of those questions. And also you can connect to me via WhatsApp in a number which is available in the screen. Again, thank you for watching and please do not forget to like, share and subscribe to the channel Contract Simplified.